Welcome everyone to this Privacy Rules live webinar on the recent Schrems II case, the decision that invalidated the EU-US Privacy Shield. As you all know, this is one of the hottest topics of the moment, and it's particularly complex because it involves the European Union, the United States, but somehow also third countries, and basically it determined the need for every company dealing with the exchange of data worldwide to ask help to experts coming from different countries, because you always have to know if your country is compliant with the regulation, and so you can use the instruments that are provided by the GDPR. In order to touch this very broad discussion, Privacy Rules has invited some of these experts coming from different parts of the world. We have representatives from the United States. We have Michael Metardi from Frost Brown Todd that will act as a moderator today. We have two experts from the European Union that are Volker Wodianka for SKW Sparks, and also Jean-Christophe Chevalier from IDES Avocats in France. And finally, we have Gabriel Avigdor from DataLex LLC in Switzerland that will speak a bit representing the third countries that somehow needs to keep an eye on what's happening, because this may involve also other countries. We will discuss in another webinar, in our next webinar, about the effect of this decision for third countries. So today we will discuss a bit more on EU and US, but Gabriel will be with us in order to give also this perspective already today. So finally, just one thing, if you have questions, please write to our Q&A that you can see in the bottom of the screen, or in the chat texting to me and not directly to our expert. And I think it's all from the Privacy Rules perspective. I would like to thank all our speakers for being with us, and I would like to thank our audience for following us today. So without further delay, Mike, I turn it over to you, and thank you again for being with us.
Excellent. Thank you very much, Alessandro, as always, for all the great work that you do for Privacy Rules. I want to thank all the panelists for being here with us today, especially on such notice, as this is really a decision that has impacted a lot of businesses across the Atlantic. And I just wanted to start off with Gabriel. And first of all, I wanted to thank Gabriel for being a part of this panel. And that is not a pretend screen like I've got behind me. That is a beautiful scenery that he is bringing to this panel. I want to thank you for that, my friend. Thank you for joining us, and we'll start with you. What exactly is this decision, and why is it so important?
Thank you, Michael. So yes, I'm live from the mountains and vacation, by trying to attend also to this live webinar to discuss with all of you the future of data transfer. So it's so important because this case originates from Edward Snowden. So the revelation from Snowden back already, I think, in 2013, and further to this, it was another activist, Maximilian Schrems, who today is really the one that is at the center of this, of those questions for privacy, because he has also founded an organization to support all those actions. So as an activist in 2015, he made the safe harbor invalid, which was the transfer mechanism already from EU to the US. So he in a Facebook case, he already managed to make this invalid, and the EU had to put together a plan almost in an emergency to find an alternative way and a more protective way for EU data to transfer that to the US. And this is why the Privacy Shield replaced the safe harbor. And today, in this decision, which is not really a Privacy Shield decision, this is a decision on mechanism to transfer personal data to the EU, from the EU to the US, questioning the standard contractual clauses. And by the way, those standard contractual clauses were assessed, and together with the Privacy Shield. So the Privacy Shield today is deemed invalid again, although replacing as a more protective way the safe harbor. And also now the SCCs, although the European Court of Justice is saying this mechanism is still valid to transfer personal data to countries that do not have an adequate level of protection, such as in the US, but also other countries. This is for the exporter to assess whether the legislation of the country to which the data is exported, the exporter is responsible to assess the legislation and basically to see whether, based on the SCCs, this mechanism is still sufficient. So it would be a case by case. And the importance of this decision is that it is affecting any companies, because third countries are any countries around the world, and it is especially affecting EU and US data transfer mechanism. We know that most of the ecosystem of data transfer are at the point of time going to the US, and this is also impacting a country such as Switzerland and other third countries that we will discuss today. So I think that's why it's so important, is because it's affecting everybody, and it's going to be more difficult today.
Excellent. Thank you so much. And I think that is a great summary of the importance of this. And Volker, I'm going to turn to you. We're talking now about, was this decision expected in the EU? And if so, were your clients already preparing for it?
Thank you, Michael. I think it was not really expected in a way that, especially we see it now on the effects on the standard contractual clauses. I think also it was kind of surprising to see the privacy shield being invalid as such so fast, because we all do remember that there were evaluation processes ongoing, and every legal counsel, every privacy expert who followed these news was, of course, eager to see that it passed all these evaluation processes so far done by the EU. So, of course, the European Court of Justice is its instance itself and has an opposite opinion on that. So, but I think to answer your question, it wasn't obvious. What is of course part of also our advisory in the last years, because as Gabriel said, what we saw with the Safe Harbor, seeing this self-certification tool for third country data transfers, in this case the US, in doubt. Practically, I can say to make it really work, or to recommend our clients to rely on this process, there's training necessary and a lot of more work than doing a self-certification. This was at least my understanding how you should base data processing on tools like the Privacy Shield. Anyhow, I think that the big problem for the international data transfer now lies in the second and third lesson that we learn from the court, that also the standard contractual clauses are under a special observation now, and which is what I might speak now, of course, from the German point of view here. We have multiple data protection authorities in Germany with not the same view, also not in this case. So our clients need to look specifically at the data protection authority that they are competent for, that they are responsible. And to give just a short example, when you take now where I'm based in Hamburg, the Hamburg DPA, the authority, makes up exactly that problem and says, okay, we now have the task to also check whether standard contractual clauses will be valid in the future, but nothing more. Okay, we wait for some news in the future from the Hamburg authority. When you check the website of the Berlin Data Protection Authority, they already recommend, please move your personal data back from the US into the European geographic area. So very, very, yeah, clear, but different views on that important case in Germany.
Wow, wow, that is just amazing. Thank you so much, Volker. And Jean-Christophe, given what we've just heard, and I know it's a lot to unpack, what's going to happen in the EU now? Where do we go from here?
First of all, thank you everybody, and thank you everybody for your presence, and thank you for Privacy Rules for this organization. And so, what can I say? The decision was quite expected here in France because, as we already mentioned, and as everybody mentioned, due to the fact that within the first French decision, when the safe harbor principles were invalidated, all the companies in Europe and in the US decided to put in place immediately under an emergency way standard contractual clauses in order to face up the consequences of this decision. But due to the fact that the privacy shields arise and then we implemented within Europe the principles of the GDPR, we could expect that there was discrepancies between the GDPR principles and the privacy shield principles, and so it was quite expected as. And when we read the decision and we see how it the reason why they consider that the privacy shields should be invalidated, that are based on the fact that the limitation of the protection of personal data are arising from the domestic law of the United States and the access and use by US public authorities of such data transfer from EU to the US. According to the court, such limitation goes against the principle of proportionality. So this clearly creates a problem. This is clearly problematic, and this is the reason why the privacy shields should have been invalidated. The consequences is today, and for the French Data Protection Authority, is that they are for the moment analyzing the decision and they are meeting all the other supervisory authorities. So I hope and I expect that they will provide some guidelines and recommendations in the few weeks or maybe in the few months. And I hope that it will be in the few weeks because we will have to respond to all our clients and all the European companies that are transferring personal data outside of EU and especially in the US with the companies that have adhered to the privacy shields, and that if we go through the GDPR terms, we should stop all the transfer. I mean, this is not the answer, actually. we will not cut the world and we will not shut down all the transfer now. But so hopefully the SCC are still valid, but I expect that the SCC will be amended by the EU. Maybe they will be updated because we are waiting for that for 2 years now, since 25th of May 2018. And I also expect that we might find an adequate decision as EU made with Japan and other countries like Argentina, with US, in order to avoid any new trouble and issues and case law issues. Because even if the SCC clause are still valid, there is an obligation now that is set out on the head of the data exporter that will have to assess that the data importer will fully comply with the principles of the GDPR and will fully comply with the security measures and so on, which clearly means that we will have to open the question of the right of audit of the data controller within the data to the data processor or the other data controller that is based in the US. So it's gonna be a very interesting topic to follow up in the next weeks. But again, to me, and I will advise my client to enter into SCC if they don't have a SCC in place, and try to emphasize some obligations in order to make sure that they can comply with this audit obligation and this obligation to make sure that the data exporter importer will comply with the regulation.
Very good. Thank you very much. I think that is that's a lot that we're obviously having to do, and a lot that we're just having to wait and see, as you state. Now, I can speak from a U.S. perspective that there isn't necessarily panic, even though I think that of course we never like being told that something that we had in place was by a different country was not good. So that's just the American pride, I guess, or hubris. But I would say that for a lot of clients that already were not relying upon that shield anyways, that had SCCs in place, this is not too drastic a decision. Of course, it could have been, as Gabriel mentioned earlier, if the SCCs had also been struck down, which would have been just catastrophic from the U.S. perspective. Obviously, those companies in the U.S. that have been relying and put all the effort into becoming self-certified through the Privacy Shield are having to do some scrambling. And Gabriel, I'd like to take it back to you. So this change, would this also affect third countries? And I think that you referenced this earlier, such as Switzerland. And with that in mind, are you somehow preparing for this? Were you preparing for this change? And are you ready for it?
So in terms of readiness, or in terms of anticipation, I think it was pretty clear that the Privacy Shield, should it be a question that the EU Court of Justice would tackle, yes, it would probably very likely be invalidated. So I think this is something that we were prepared for. About the SCCs and the supplemental obligation that now we would have to put in place, and how for each and every single data transfer we would have to assess what type of data and the types of services and how the responsibility on this data transfer needs to be addressed in the SCCs as an additional contract negotiation. This is not something probably we would have anticipated. In terms of how we can think for the future, I think today, so that the Swiss Federal Commissioner issued a press release saying that they are looking into the judgment. So Switzerland is a third country. However, we have the adequacy decision. We still have it because we have our old data protection law from 92 that is under a full and complete revision, but it's still not entered into force, and there are still something to put in place before it gets ready. So we are also in a bit of harshing a bit so that we can amend that so that we can keep our adequacy decision. So obviously, if we still keep the adequacy decision, at least as a third country, we would be in a position where we know that any data transfer with the EU is going to be fine. However, then what to do with the US? We have our own privacy shield, the Swiss-US privacy shield, which is almost the equivalent to the EU US privacy shield. We don't know to what extent it's going to stay in place. It is very likely, to my opinion, that the federal commissioner would say that it's not a legal basis that is valid anymore, and the federal council will have to make a decision to either maintain or say that it's not anymore in place because it doesn't respect enough, based on the EU decision, the rights and freedoms and the principles of data privacy in Switzerland. So in terms of next steps, I think we'll have to hear a bit what types of mechanism we could rely on. In Switzerland, we have our new law, and the new law in terms of what mechanism we can use to transfer data abroad. First, I can say that you can also refer to another webinar that we did with Privacy Rules on data transfer. So if you want to know exactly what are the principles of data transfer mechanism, you can refer to this webinar and everything is explained. And now, in terms of what remains in terms of mechanism for the future, for data transfer outside of an adequacy decision. So we have the possibility to have international treaties, contract clauses that we can submit to the federal commissioner, but first it means each and every single contract, which is very burdensome. And you will still have like pre-approved model contract clauses, which probably we will just stick to what the EU is going to do, because if the EU is going to say, well, Privacy Shield is down, we will probably say it's down, or even though we could say, well, it's still in place. But we could do that, and we would probably do the same for standard contractual clauses, saying, well, the EU is amending and updating to the GDPR, and we are going to probably rely on an updated version of our own standard contractual clauses. So I think we are waiting a bit for guidance in Switzerland to see what is going to happen with the EU as a third country. Yeah.
Very good. And I think that that's a common theme here in a lot of the responses, that there is going to be some wait and see, except for, and we'll get back to Volker here in the next question after I go back to Jean-Christophe, because there's going to be a lot of wait and see, except for Berlin, it sounds like. Berlin has already kind of ran ahead. But Jean-Christophe, the CNIL, as most of the EU DPAs, has not said anything yet. I guess that we've talked about the outliers in Germany, but is there an idea on what might be the CNIL's direction? And if so, how long will it take for them to come out and give a reaction, given this uncertain situation?
Honestly, I was expecting that a press release or some recommendation would have been set out within the weekend from the decision date and today, but unfortunately the CNIL did not make any decision or make any recommendation, and say that they are going to meet with the European Community for data protection. So to my understanding is that they're going to work with the other supervisory authority within Europe to propose and provide some recommendations. So, but for the moment, in terms of timing, I would say that we should see the recommendation coming out within the next few weeks, and maybe let's say months, because we are close to August, and everybody knows that in France, especially, August is very, very big, important months in terms of resting. Anyway, so it's going to be holidays, and but if we go through the actual legislation and the Data Protection Act, there are some exceptions that allows the data transfer outside of EU, and we don't, whatever the countries where we go. So, and which are quite the same exception as the one set out by the Article 49 of the GDPR. So the contract, the consent given by the data subjects, and the fact that you have set out SCC clauses with the data importer, otherwise that you have BCRs. So I would say that the recommendation will be, we follow up and continue working with SCC. They will not say you have to stop data transfer, but they might say, given the fact that your partner, your US partner, has only adhered to the Privacy Shield principles for the moment, if you are discussing with them, then you take the other way immediately and you enter into SCC. So that would be my recommendations as a lawyer, but I would expect that the CNIL will say that as well. And again, the CNIL is also working at the moment on specific guidance on BCRs. So maybe they will take the opportunity of this decision to modify and give the recommendation on that aspect as well.
Very good. Thank you very much. I think it's a great segue back to Volker, because as you referenced earlier, the two different responses from the organizations in Germany, both Hamburg and Berlin. If you can, and I understand if it's not possible, but if we can, put on the prognostication hat a little bit here, and we're going to ask you to do that a little bit for us as it relates to Berlin and Hamburg. Let's unpack a little bit more what exactly the Berlin commissioner said and what that's going to mean, and then also recognizing the difference between the commissioner in Hamburg. If you could talk a little bit more about that for us.
Or let's also try to simplify it again, because of course there's like an organization or like a circle, it's called Düsseldorfer Kreis, that tries to harmonize the DPAs in Germany. So we expect, of course, one voice on this matter in the future, so that the DPAs come together and speak with each other and recommend how to deal with this matter for all the companies in Germany, and not a very diverse understanding of the decision that makes business, of course, very difficult also for companies that look at Germany and want to do business with Germany, because this is also a part of harmonization that takes place in Germany, that DPAs come together and deal with this matter in a unique form. So I don't think that the Berlin view today is an example that will come into practice. But let me also say that from the past, from the safe harbor times, we didn't see any grace period. Let me clearly recommend that companies that today do rely on the Privacy Shield with their data transfer into the US should not wait and but should take action and move to standard contractual clauses. That is a very clear recommendation, because we saw fines in the past, and it's easy for a DPA to check in the past with Safe Harbor, today with the Privacy Shield, send letters around, and that happened. Do you still rely on Privacy Shield, or those days on the Safe Harbor with your third country data transfer? And if they replied correctly and they had an issue there, they paid a fine. So these were like, in Hamburg, we had numbers like 15,000 euro, not still say I saved that money. So I absolutely recommend to manage this issue, because also GDPR says when you take technical and organizational measures, and organizational measures means check your Article 30 data processing register, check third country data transfers, ask your providers also, and this is, I think, an important aspect, because I also see in our chat a participant from India, the India perspective. Let me just take this as an example, because that question came also to me from an Indian privacy lawyer. They do, of course, a lot of sub-processing. So in the contractual chain, we have maybe Germany, Europe, let's take it from us now, but then we have a sub-processing in a third country. So I think it's very important now to identify where are third country data transfers, maybe not in the first place, but in the sub-processing part. And then again, take action. Ask your provider, do you have this compliance aspect ready or not? Maybe you would like to change your provider or implement the SCCs. So it's about managing this issue now in the next weeks. Identify where you have these third country data transfers, yeah, document what you do, because then through GDPR you would not risk really fines. This is my understanding. When you can yeah, make accountable that you saw the case, saw the decision, and manage it, no? The best as you can right now.
Very good. Thank you so much. That is an excellent point that you also bring up about the sub-processors. Very good. It's something that should definitely be considered. And I know that from the U.S. perspective, you know, what we're really going to be focused on is that if there is only been reliance upon the shield, you know, companies are going to have to find as quickly as possible the legal basis for the transfers in order for them to continue. The easiest, I've always thought and continue to think is the SECs. But, you know, we've discussed that there are some other ones, including the binding corporate rules, and then also seeking the derogations, or at least the agreement from the authorities within the countries themselves. Have any of you all, and this is off script, but I'm going to ask, does anybody have an idea of if a company was going to actually seek that type of comment themselves to get approval from the DPAs in your respective countries, the time frame involved in that? Anybody have an idea? Anybody want to? And if you don't, that's fine, because I know I'm going off script here, but I think that would be helpful to discuss.
Maybe I can give an example concerning binding corporate rules, but which only applies for of course the transfer in the group in a global company. So when you have third country data transfers in your group company, that is a solution. And concerning timeline, it's about 6 to 8 months, roughly speaking. Well prepared by an advisor. You need a privacy policy, and then of course the leading DPA needs to check these documents, and this is but just very roughly a time frame that would apply to the binding corporate rules BCR.
Very good. Thank you, Volker. That is very helpful. So it's obviously something that you've got to get moving. That's not something that you can just get by the end of the week. Anybody else? Jean-Christophe, any thoughts on that?
To complete Volker's position and advice on that, for BCRs in France, it can take very long time because you have to prepare a very, very strong file, and then you submit it for a registration and validation by the authority, and it can take several months. It depends on the complexity of the transfer and so on, so it can take a lot of months. Usually, I mean, a few years ago, it was nearly 2 years. Now it's going to be faster, I think, but it's very long. And if you modify the MCC, the SCC, then it can be complicated as well. So you have to request an authorization to modify such SCC. So I would say the recommendation would be you set out the SCC and don't modify it, but you can emphasize it.
No, very good. That's very good.
And easier. Yeah.
No, that's great. Thank you very much. And Gabriel, you know, you and I being attorneys in the U.S. and Switzerland, you know, not a part of the EU, we've talked about this a little bit, but just to kind of underline the importance of it, how should we be advising our clients and companies right now, given the status and everything that we've heard so far today?
Yeah, as a third country, I think the difference is that we still have the adequacy decision. I mean, in Switzerland to be monitored, obviously, for Switzerland, as we hope we will maintain it. But in terms of best practice and recommendation, I would say I follow the fact that you need to assess your legal basis. You need to see whether on what you rely, because you have many options. We see today that the options are a bit limited and more difficult to rely upon. So if you rely only on Switzerland, US Privacy Shield only for the transfer of personal data, I mean, the risk for Switzerland that the Federal Commissioner says that it's no longer a legal basis, I mean, that's a high risk. So that's a risk that you should assess for transfer to the US, especially for the US. If you rely only on this mechanism, you should switch immediately to another mechanism. If it's internally, I mean, you can use, you can, you know, BCRs is long to put in place. It's not that easy to draft for multinationals. So as an immediate effect, kind of putting some kind of standard contractual clauses in intra-company controller to controller and controller to processor agreement between affiliates and the group is something that is still safer, because it's still a valid mechanism. But check your legal basis, and you may be a small organization where the GDPR does not apply. So in Switzerland, we still have a lot of businesses to whom the GDPR does not apply, and we still have the Swiss Federal Data Protection Act that is applying with some similar principles, but still it's not the GDPR. So when you don't have the GDPR applying to you, such as when you are, I don't know, a doctor or a hospital or a startup, and you aim to do business or to send personal data using services from the US, check what mechanism you may have to transfer data over there, such as you may see that, you know, you could use consent if it's one single shot, but consent is very difficult because consent then can be withdrawn. So when someone says, I don't agree anymore, what should you do? You should stop processing, potentially deleting the data if that's the request. So consent is very difficult to rely upon. You still have other types of legal basis, such as public interest or performance of a contract, or exercise of the legal claims, or public interest or vital interest in the health sector. It can be possible, but still, I think the recommendation immediately would be to switch to let's say still an easy mechanism to put in place because it's still known in the industry. However, I would say, so first, assess the legal basis. Second, assess the type of data that you are sharing, because obviously the harm for the data subject will not be the same if you share patient data or children information to the US or a third country, because you need to assess the legislation of the country, compared to just an email for remarketing. So this would be, I think, something to check in really pragmatically. What I mean, go through your mapping and your records of processing. If you're a small company, you've never done this in the past, just it's really the occasion to do this. Check with whom you do business, and if you want to buy services from those giants, don't forget that Salesforce, Amazon, and Azure, they have huge data centers, and most of the time you can choose which data center you can use. So you can still use them and having your data centers in the EU, like in Ireland, Dublin, or Paris or Frankfurt. For Amazon, for example, you have those, and let's say for France, it's also served, because I've been having a case at the moment. So it's also okay for the HDS certification, this certification which is compulsory for French health data. So check to what extent the data is. You can have an option to have it in the EU. This is going to save you probably a lot of work in the future if you can do that. So that would be the kind of advice, to see the type of services, the type of data, and the legal basis. For Switzerland, waiting also to see what's going to happen from the authorities in Switzerland.
That is fantastic. Go ahead, Volker.
Well, let me underline, thank you, what Gabriel mentioned with the location of the data center. That is also my my experience that, of course, our clients already in the future, in the past, sorry, tended to ask where are the data centers of the bigger companies we all know. And it is possible to locate them in Europe. It is possible to locate them in Germany if you want. But you, of course, then need to be very strict in the contracts and really take care that this is a fixed clause. And also let me mention, don't forget the maintenance and care services that usually do apply in these in these contracts. They might also open the box again for third country data transfer, because this is something that might be provided in hours of the day during the night from another country, of course. So but if you have a close look at these issues, the geolocation of the data centers, that might be in Europe, so perfectly okay, and also where maintenance and other access issues. We know all data transfer already is in place when somebody can see your data, no, through a TeamViewer or whatever. When this is all located in Europe, we don't really have an issue, no? So I think it's important also for the US companies also not to panic, but also to think about providing these services in Europe. That makes life easier for the clients here, of course.
Fantastic. That's great information from all of you. I really appreciate it. It's been so helpful for me just to be a part of this panel, to be moderating the things that I'm hearing, that is such great information that I know will be a benefit to my clients. We do have some questions here that have been coming in from the people that have been watching. We want to thank you for those. And at this time, I'm going to ask Alessandro if he would like me to ask them or if he would like to ask them.
No problem at all, Mike. If there is a question that you were already looking at in particular, you can just start asking them. I will try to keep staying on, watching all the questions we are receiving in order to manage them and trying to answer as more questions as we can in these last 15 minutes that we have together.
Great, thank you so much. And I guess the place that I'd start is that interesting question that Volker referenced about given the increasing surveillance efforts by the government of India, plus the absence of a data protection framework, what is the impact of this decision on India? Would anybody like to take that one on?
Well, as I said, or just to underline it again, I think India today relies on standard contractual clauses, which is perfectly okay. Actually, I don't have information that data protection authorities see in another focus than other third countries at the moment. But of course, it's when you provide services from the geolocation of India with employees that are based in India, it's important to question this framework, no? And how difficult it is also from the marketing perspective to say, yes, our services are or need a third country data transfer, no? Also many...
Alessandro, can you hear Volker? I apologize, yes. I'm not able to hear him.
Yes, I can hear him.
Oh, you can? For some reason, I've lost my audio.
Okay. No, but I just want to say, I think India is not in the focus of being not regarded as a country where you can't we can't work with SCC. So, but maybe Gabriel or John has another view.
So, I mean, just a short thought from my side. I think what would, from an exporter perspective, not from an importer, maybe for India, but at least from an exporter perspective, you have still, I think, a limited number of countries to which, I mean, like key countries to which you will have to assess the legislation. And I would think probably of the United States, obviously, to check, for what type of data you could put, more strong obligation in a contract and in the SCCs. But obviously for India, I mean, if someone says that the surveillance power of this country is going to be increasing, obviously it might be that the SCC might be less easy to implement for this country. But I would think also of China and some other Asian countries, like big countries to which you would have more oversight from the state, so that I mean, those companies would be those states would be assessed. I don't have the answer for India specifically, but I would think that you need to really think about the type of data with too much fear, and for which data it could be more complicated to ensure that it can be I mean, using the SCCs as a mechanism is okay.
Sorry, Gabriel, I just
Just
missed a
mapping.
few words on what you were saying in this last part. Maybe you can just repeat the last part of what you said.
So I think my headset has just died.
Okay.
No, I was just saying, in terms of, I mean, pragmatically, just checking those types of countries, those key countries, such as US, China, India, and maybe other countries to which you are sending or using services from, and then mapping that with the contract and mapping with the type of data that is planned to be sent there. I mean, if it's children, patient, other types of very sensitive data or opinions, I mean, HR data, I mean, for those type of data, I would be very cautious to review exactly what you do and potentially switch. This is obviously something to consider. Switch the service or the provider if you cannot, because you do really share data with a distributor or a business partner that is located in a country like that as an importer or as an importer of data. Really check with them and discuss. Otherwise, potentially plan B would be to switch. But if you only have the supply chain with a country like this, assess and discuss with them how to put this together so that it can protect the data that you are sharing.
Perfect. Thank you, Gabriel. Just let me jump in 1 second, Mike. Sorry. In this regard, speaking about third countries, I just wanted to underline that we will discuss these also in our next webinar, and we will try to invite exactly the countries that Gabriel were mentioning and for which we are receiving questions. So let's see if we will be able to provide an additional service to our audience of today. And there are another couple of questions. Mike, no, I don't know if there was one specific you wanted to ask. I see one of location of data center that may be interesting to touch.
Yes, if you want to go ahead and ask that one, go ahead and ask that one.
Yeah, I can just mention this one. There is this interesting question on location of data center is important, but if a US company own the data center or provide the service, what about the obligation for the US company to provide data to US authorities under request? That's an interesting one. I think.
Very interesting question.
Yeah.
Anybody have any thoughts on that?
I think, Mike, that you can start on this one.
Well, I mean, I know that that will be something that I think that's at the heart of all of this, really, is that the relationship of the U.S. companies between the U.S. authorities and the surveillance that everyone is afraid of, that's led to the eradication of the safe harbor, and now the privacy shield. And so the question then becomes, what are the U.S. companies going to do in terms of resisting the surveillance attempts by the U.S.? My guess is that the U.S. companies will, if anything is public, would resist any attempts by the U.S. to do anything to get information, as I think that it's been clear that they have for a while. However, the concern is always what you're not hearing about. And I think that's what's led to all of the backlash, is that there's a difference between a company receiving a subpoena as part of a public proceeding, and then going to court on that subpoena, and receiving something under a FISA court that is secret. And so that you don't have the ability to go in and fight. And so I think that bringing out that difficulty is going to be the battleground on even choosing an American company that has a data center in the EU. Any thoughts from anybody else?
I can see Gabriel. Yeah.
I just have a thought on companies. Yeah, so on some companies that will have for some obligation that come from local legislation to share information to the authorities. If this is an obligation by law, like, I don't know, if you're submitted to the oversight of a financial authority or a health authority under HIPAA, for example, or the FDA, I mean, there is no problem to me at all for this. You need to distinguish between the obligation according to the law to do this, because in any country you may provide information, data as part of an obligation in the law, or if you have to defend legal claims, to me that's okay. That's not okay, and that's really the heart of the thing. If you have like an extra power of the state to then obligate the controller to say, well, I want to do surveillance on that, and you need to provide that because not only it's a legal obligation, but because we just want to check what is in your records, because we just want to do surveillance. So based on surveillance activity, that's probably not the same as just having a legal obligation to provide information as part as the local legislation. So I would probably you may probably want to do the distinction between the type of information and the type of, and Michael, just react if you have another opinion, but I think you need to distinguish really because of this, because to me this would be, I mean, in any country you could potentially have to provide, I mean, to tax authorities also some personal information. So I think that's really the heart of this, and I think that I saw some discussions on restricting in the SCCs, specifically in those, what we call those SCCs plus, or maybe 2.0, I don't know the name that we can use for them, trying to restrict how information can be shared to outside of the business. I think that's going to be the next discussion, but feel free to react on this one.
Oh no, I think that you raise all the right points, and that is great. I think that a lot of it for the U.S. side, I mean, let's just be honest, is perception. You know, is that you're exactly right about the other legal means, but my concern is going to be, and I don't think I'm speaking out of turn here, is that no matter what we say, or we're going to do, I think there's always going to be the concern or the fear that the U.S. is doing more. That's under the table, if you will.
Yeah. I can see Volker maybe has something to add. Yeah.
Let me also underline. I think when we talk about controller-processor relationships based on GDPR, we talk about, of course, liability and responsibility. For a controller, it is of course important that it is not obvious that personal data is being processed in a way which is not compliant with the law. But let's face it, every country around the world has national security interests. And what I always taught my clients, and also doing my think about the responsibility of a CEO of a company. No CEO of a company in the world has the obligation to protect the personal data from or against security agencies, because you're not able to do that. And of course, there are national security agencies in every country where you process personal data. The problem is, and which was with the Snowden case, that he made clear to the world that it happens in an excessive way and above the laws that apply in the US as well. We have anti-terrorism laws, which are very important in the US and also in other countries. And there are mechanisms that ask for like a judge decision before you access personal data. And the only thing is that Snowden explained to the world or said that they don't care. So, and then of course the CEO in Germany and another country as well has to face this information and say, well, I can't obviously send the personal data to a country where they don't care. And but that is the problem. Also, to come back to the Indian example, when we would have information in Europe that in a certain country the laws that apply to protect and regulate the work of the security agencies, no? The intelligence agencies, that they don't care about their own laws, then we really have a problem, no? Because then obviously you cannot protect the personal data there. So I think this is always the issue, and that's why we have this. I think there's line 191 in the court decision that makes clear that the European Court of Justice has strong doubts that the mechanisms to control this work of the agencies doesn't work properly. So I think this is, let me propose this also the solution for the problem here. No? When you make that control mechanism stronger and more reliable, then I think we really come to a very, very different view.
I think that is a great place to end, right at the stroke of 11 here in the Eastern Standard Time. I think it's 5 for you all. Alessandro, if you want to wrap it up, I think this has just been fabulous. It's one of the many reasons I'm so proud and honored to be a part of the organization with you all. What a great discussion. And Gabriel, thank you for coming in on your vacation and giving us that beautiful view, my friend.
Yes, thank you very much. Thank you very much to you all. Yes, there were still some questions, but time ended up, so we will eventually try to answer to those questions with other materials in the future. It was a fantastic panel, a lot of topic to be discussed. I think the issue we were handling today is something that would need kind of days to be discussed and touched in all its parts, but I think we did a great job in order to give a broader overview on what's happening, and we will continue working this way. I would like to thank you very much, all our panelists for being with us today, and also, yes, Gabriel for being with us even if in his holiday season and giving us this beautiful view behind him. And I would like to thank all our audience for joining us and finding the time to ask questions and following. I think the questions of today were really interesting and made the discussion even more insightful. So thank you all very much. I think we can close here, and I hope to see you everyone very, very soon again. Bye-bye.
Thank you. Bye-bye. Enjoy your summer.